Hello and welcome to Beyond the Launch TV. I am your host, Attorney LaConya Murray. I am the owner and founder of Off the Mark IP Solutions, where we help clients throughout the United States with trademarks, copyright, and business development solutions. Thank you so much for joining me. I really do appreciate you coming here today on this Thursday. We are thinking about bringing back Ask Me Thursday. This is the day that we answer questions that are submitted to us from our fellow entrepreneurs and business owners that are out there. And just keep in mind that these questions are general questions. They are not, the answers that I provide is not legal advice, but really just legal information so that you can know which direction you need to go and have better informed questions when you do contact your attorney for your particular issue or matter. So Kayla Wright is the owner and founder of Mess in the Bottles. They produce t-shirts that have awesome messages on them. So they have t-shirts, they have luggage or bags, and they also have coats. This is the packaging that her t-shirts come in. I had the pleasure of meeting Miss Wright at the Black Entrepreneur Summit 2 weeks ago now, and this is the packaging that it came in. I had a great t-shirt. It had "Be Great" on there. I would have worn it today, but I had a client meeting, so you know, it's whatever. But she posted this picture on her website or social media channels last week. And if you look at the picture, what you'll notice is that you see a picture of her packaging, which is this Mess in the Bottle, which is a bottle, reusable bottle that you can, open, take. It's really nice. I hadn't seen anything like this before. And she posted her picture next to a new Louis Vuitton product that is out, who has a similar packaging now of having their t-shirts in a bottle. Not as cute as this one, this Mess in a Bottle, but still very similar to hers, enough that other people who are very familiar with her brand, she didn't have a small brand, she has celebrities wearing her brands, such as like Serena Williams has a coat that she got from Mess in the Bottle, and I know that she's a really popular brand. So a lot of people took notice that Louis Vuitton that basically copied her style. And with that, they cried foul, and they were like, what can you do? Because there's a feeling out there that as a new entrepreneur, as a smaller brand, there's a lot of things that you can't do. You just don't have the recourses and the resources of big brands. Some people want to know if it was copyright infringement. And so the answer to that, no, it's not copyright infringement, but it could be a little thing called trade dress infringement. So we're going to talk about that just a little bit today. So what is trade dress? Trade dress is a form of trademark protection. Trademarks protect the source of a good or a service. And a lot of people think of trademarks and they think about logos, and they think about short phrases, and they think about even like their trade name. But trademarks protect so much more, like legit, it protects so much more. And one of those things that it protects is packaging. It can protect packaging and even the atmosphere of decor. So you think about packaging, you think of, this is a unique package. If you saw this bottle, you would automatically think of Mess in the Bottle and her brand. So that is the point. So trade dress refers to the characteristics of the visual appearance of the product or the packaging. Okay, it's the thing. What is it about that package that makes it unique? What is it about that package that makes it stand out from the competitors? When I think of packaging, I think of a case not too long ago of Pepperidge Farm. Pepperidge Farm, they sell cookies, and they have this unique packaging to them. Not too long ago, they had to sue Trader Joe's because Trader Joe's decided to use very similar packaging to the point where it was similarly confusing to consumers. And so, because trademark or trade dress is a form of trademarks, you still are looking for this likelihood of confusion when it comes to infringement. But before we get to infringement, let's talk about the number one thing that you have to realize when you're talking about trade dress. When we're looking at trade dress, so not only are we looking for some of the common factors, that's when you have a trademark, meaning is it inherently distinctive, is it unique enough, you also want to make sure that it's not functional. That is no function to it, because if it has any type of functionality to it, then it's a possibility then it will not be it cannot qualify as a trade dress. So if you have a package visual aspect of it, it cannot be functional. Meaning, so what do we mean by functional? Let's talk about functional real quick in this our 5 minutes of fame here. So with functional, meaning that is this what the consumer expects from the product? I know when I buy a t-shirt, I don't expect for it to come in a bottle. Okay, I expect for me to be able to wear it. If it was like a drink or something, you know, like if I was buying a Coke, I would expect for it to come in a bottle, and so that bottle itself would not be protected by trade dress as it relates to Coke. But it's a very interesting fact that Coca-Cola actually does have a trade dress trademark for the shape of their Coca-Cola bottle. So it's for the unique shape of it, and if you look at a Coca-Cola bottle, which I don't have, but if you go to the store and they bring them back, you'll notice that it has like ridges in the bottle. So that part, that visual aspect of the bottle is protected by trade dress. Basically what they want to know with functionality is like, is this necessary in order for this product to work? If the answer is no, then you're one step closer to trade dress protection. When it comes to proving infringement, it depends on what courts you're in, who has the burden of proof. In some courts, the plaintiff, the person that owns the trademark, has the burden of proving that the trade dress is not functional. And then in other courts and in other circuits, it's up to the defendant, the one that's been alleged to infringe on the trade dress, to prove that it is functional. So it really just depends on what court you're in, who has the burden of proving what. But when you are in court and you're trying to prove trade dress infringement, there are 3 things that you want to look at. So the first thing you want to look at is that, again, the functionality. Is it functional? Like that, when you think about trade dress, I want you to think about functionality. Is it functional? If it's not functional, then we move on to number 2. Is it inherently distinctive? Like, is it really, when people see this product, when people see this packaging, they really think of your brand? If the answer is no, if it's really similar to something else, then it's more than likely not going to qualify for trade dress, because again, it has to be, when people see this, they have to say, oh my gosh, that's Coca-Cola, that's Pepperidge Farm, that's mess in a bottle. They have to have that reaction, like when they see a bottle, like if I saw this bottle like this with a t-shirt in it and it didn't even have any writing on it, I would automatically think of mess in a bottle, because I know that's how she packages her t-shirts, and I have not seen any other t-shirts packaged in that way. The third thing you want to look at, so the first thing you want to make sure that it's not functional. The second thing is you want to make sure that it's inherently distinctive and unique, so that people actually think of your brand when they see that packaging. And the third thing is likelihood of confusion, because bottom line is, so we see bottles like this that have tennis balls in it, right? That's not going to cause any likelihood of confusion with a t-shirt company. So when you're looking for likelihood of confusion, you want to see if consumers, when they see this product, do they confuse that product with someone else's? You know, do they think they're getting one product and they're actually getting another one? Do they think they're supporting one business but they're actually supporting another one? And you're looking for same or related feel, which is like with tennis balls. If you were to fill the bottle with tennis balls, there wouldn't be any likelihood of confusion. However, when you start putting t-shirts and other articles of clothing in there, then it gets a little suspect, wouldn't you say? I would. And I'll leave you with one more point. When you're creating these brands, when you're thinking about how can I really make my mark in commerce, think about your trademarks. Think about your branding. Think about how you can make your branding unique. And when you're doing that and having that conversation, make sure you're in contact with a brand attorney that can make sure that what you're doing can be protected, because that's where the money is in the protection. You want to be unique. So with the trademarks, one of the points of the trademarks is that it gives you the exclusive right to use that. So no one can use anything that's same or similar to promote their product. So that's why you want to make sure that you not only developing a brand that's unique, but also protecting that brand. So developing that brand is the first step. Protecting that brand is the second step, and then enforcing your trademark is the third step. So that's what I have for you today. Again, my name is Attorney LaKanya Murray with Off the Mark IP Solutions. If you have questions, make sure that you email us at hello@offthemarkipsolutions.com, or you can find us on Facebook at offthemarkipsolutions.com and drop your questions in our DMs, or on Instagram, you can DM us there and find us at Protect Your Mark. Take care.